Good afternoon. At this point, you've probably figured out the drill. We're going to introduce ourselves. We're going to have you introduce yourselves. We're going to have a conversation. We're going to have some fun. And at least for myself, I'm highly caffeinated, so I'm ready to go. All right. My name is Charlie Hinderleiter. I'm the Director of Government Affairs for St. Louis Realtors in St. Louis, Missouri. I'm a professional political nerd, past political science professor, and former competitor in the We the People program. So I was once on the other side of the proverbial table, Zoom screen. I'm not sure what metaphor to use these days. But I am looking forward to our conversation. And up next is, I don't remember what order we're going in. One of my other judges.
Good afternoon, Mark Simons. There's no chance we're tired. We're amped up. You're not going to get easy questions. We're going to come right after you. We're going to expect, we've got the high bar. We want to see what you've got. Remember, day 2, you're closing out the second day of nationals. Amazing thing. Be proud of yourself. This is your chat. Don't hold anything back and give us what you've got. Really looking forward to dialoguing with you and talking with you later. Thank you. Oh, by the way, I'm an attorney, and yes, you can actually get paid to do what you're doing up there. You just talk and people give you money. It's the coolest thing ever.
All right, Mark's been saying that all day. I'm Karen Milton from New York, and I'm a lawyer by training. I've spent my career in public service, and I'm here to tell you, if you really want to talk about habeas corpus, then you need to join the federal courts, because we talk about habeas corpus all the time. I was the circuit executive for the Second Circuit. That's the states of New York, Vermont, and Connecticut for many years. And we dealt with habeas corpus petitions, EDFA, and all this good stuff. I'm currently the chief of staff for the inspector general in the Metropolitan Transportation Authority. That's the New York State agency that oversees the New York City and greater New York transportation system. You can tell from my colleagues, we're really excited. We are not tired. We are highly caffeinated and alert and ready to go, and cannot wait to start this competition and this conversation, I should say. And let's do it. I think we have a question to read. Well, first you should introduce yourselves to us and introduce your teacher.
Hello, judges. My name is Elise Norris. My favorite philosopher is John Locke for his theory of social contract and his second treatise of government.
Hello, judges. My name is Maya Cheam. My favorite philosopher is Montesquieu for his thoughts on separation of power in government.
Hello, judges. My name is Mackay Owens. My favorite philosopher is Aristotle for his books on Nicomachean ethics and their connection to politics. On behalf of Tahoma Senior High School, our advisor Gretchen Wolfing, and Washington State, we thank you for judging us.
Fantastic. All right, we're doing question number 2. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? Whenever you're ready.
Habeas corpus secures every man here, alien or citizen, against everything which is not law, whatever shape it may assume. Thomas Jefferson, 1798. The ancient writ of habeas corpus, roughly translated from its Latin origin, means to produce the body. Thus, the writ of habeas corpus allows for the court to hand over a prisoner to review the legality of their imprisonment. Inspired by Clause 39 of the Magna Carta and the passage of the Habeas Corpus Act through British Parliament in 1679, the authority of a federal court to issue the writ was first established by a statute in the Judiciary Act of 1789.
The founder adopted the writ of habeas corpus from the Magna Carta and stated that the right to the writ shall not be suspended unless and when in cases of rebellion or invasion in Article 1, Section 9. Chief Justice John Marshall in Boumediene v. Bush 2008 states the purpose of the writ is to protect the rights of the detained by affirming the duty and authority of the judiciary to call the jailer to account. In the United States, the role of the jailer is the executive branch, and the writ of habeas corpus provides a check on its power.
Habeas corpus is essential to limited government by serving as a direct check to executive and judicial powers. This includes ensuring the lawfulness of a detention, providing the power to reverse sentences, and allowing protection from further sentences. A strong defense against arbitrary imprisonment is essential to protect the individual civil liberties of all persons.
The writ of habeas corpus has evolved throughout American history, beginning with the founders' adaptation as a response against Great Britain denying them the right to a trial by jury. Congress explicitly gave federal courts the ability to grant habeas corpus relief to federal prisoners. Further expansions occurred during the Warren Court era, in which the case Brown v. Allen 1953 expanded the writ to state prisoners where 4 men were denied both writs of certiorari and writs of habeas corpus based on the technicality of a missed deadline.
The most recent revision of the writ of habeas corpus was through the Anti-Terrorism and Effective Death Penalty Act of 1996. The act imposed a one-year limit on petitions, required approval to file successive petitions, and established that habeas relief is only available if the state court's actions involved an unreasonable application of clearly established federal law. This was reaffirmed by the 9-0 decision of Knowles v. Mirziansi in 2009. After being convicted, Mirziansi applied for habeas corpus relief on the grounds that he was denied his Sixth Amendment right.
This decision had been overturned by the U.S. Court of Appeals for the Ninth Circuit. However, the Supreme Court ruled that it had exceeded its power by granting habeas corpus relief without considering whether state court adjudication of Mr. Mirziansi's claim was unreasonable. While the original purpose began as a protection for prisoners from injustice, it is now a vehicle for changing jurisdiction, redefining how justice is determined.
Through the use of the writ by non-citizens and its abuse in order to extend sentencing time, the writ of habeas corpus places an unreasonable burden on the government. On November 13, 2001, President Bush issued a military order that called for the detention and trial by military commissions of immigrants that the president determined were dangerous.
The case Hamden v. Rumsfeld 2006 declared the order unconstitutional. The directive that President Bush wanted to pass, where non-citizens who are imprisoned by American executive forces have access to the right of habeas corpus, was created because of the burden of the writ on government.
A more prominent burden that the writ of habeas corpus places on the government is its use to change jurisdiction, either to extend the time someone is in court or to find a court that will give petitioners the results they want. Title 28 of the United States Code, Section 2266, established time limits on district courts to render final determinations on petitions for habeas corpus to prevent the use of the writ to extend time.
The issue of time and the complications of international petitions of habeas corpus continue to burden the American government today. The establishment of the writ of habeas corpus, the prohibition of ex post facto laws, are perhaps greater securities to liberty and republicanism than any the Constitution contains. Alexander Hamilton, Federalist Paper 84. Thank you.
How does habeas corpus fit with the guarantee of due process in the Fifth and Fourth Amendment? And how is that, can you explain to me from your perspective how those work together?
Under the Fourth Amendment, search and seizure is absolutely important with the writ of habeas corpus because the writ of habeas corpus essentially means producing the body, and with searching and seizuring, that amendment, it prevents the unlawful search or seizure of a person or their objects, which is really important to actually producing the body in a court.
To add to my colleague's point, I would say that due process rights intertwine well with the writ of habeas corpus because the writ of habeas corpus places that right to not being incriminated without any sort of explanation or any real reason given to them by an executive force. And that would include the due process rights add to that, just with allowing rights to those who have been taken into court with trial by jury, guaranteed right to a fair and speedy trial. Those as a combination give protections to prisoners and allows for the court system to work the way that it does.
To finalize the points of my colleagues and bringing it to a philosophical standpoint, Aristotle claims the rule of law over the rule of man, and looking at the idea that both of them have grown together throughout American history, due process works with the writ of habeas corpus in the sense of habeas corpus challenges if due process has been violated or not.
So let's talk a little bit about the historic underpinnings of habeas corpus, which you referred to. You talked about a little bit in your opening statement. Why do we need habeas corpus? We have a written constitution, we have a Bill of Rights. Why did the founders think it was so important to include habeas corpus in the Constitution?
We see its major mentioning, and the only time it's really mentioned in Article 1, Section 9 within the Supremacy Clause when you're talking about the suspension of habeas corpus, and this implication shows its importance as it is a large part of any functioning government and to be able to protect against any true arbitrary law.
In addition to my colleague, pulling a little bit of historical knowledge, the Magna Carta, there is the writ of habeas corpus, and the founders, I believe, they felt that right had been violated as they were in colonial America, and they had just been summoned. They were pulled overseas to be held in the courts there for unfair trials. So I feel that given those experiences, they were really crucial in considering what they wanted to see in the formation of their own government.
And to finalize my colleague's points, I would say that it plays a role in checks and balances. You can see in Articles 1, 2, and 3, there are several powers checking one another. I think that the writ of habeas corpus provides a check on executive power when it comes to protecting the rights of the people. And so that is why it is written in the body of the Constitution. It does provide a check. Yeah.
All right, let's go historical again, but a little less so than the colonial era. Evaluate Lincoln's suspension of the writ of habeas corpus for me.
President Lincoln used the power of he established martial law, and he suspended the writ of habeas corpus without any sort of approval from the other branches of government. He suspended it he cited his suspension under the suspension clause, which was to protect civilians in cases of rebellion or if it was a threat to public safety. And he mainly used it against the states that were seceding. However, it was not exclusive to those states.
And looking specifically to that motivation, that is a continuous motivation whenever we see any suspension of habeas corpus. It's for the idea of public safety when you're talking about 9/11 or large events of either terrorism or war that is happening within the country.
Do you agree with the concept that habeas corpus should extend to non-citizens? And if so, why?
The writ of habeas corpus is it's seen throughout the world in other governments. And in Johnson v. Eisenstrugel, the 1950 Supreme Court landmark case, it really determined that if it's a non-citizen, the U.S. in its non-U.S. territory, the United States should not have jurisdiction over them. However, as we saw and we continue to see in Guantanamo, the government is exercising its power over non-U.S. citizens in an arbitrary way. And in order to prevent that, I believe that all citizens of the world should be treated by the United States as they have the writ of habeas corpus, because it's really unfair and it's arbitrary punishment to have the continued detainment of these individuals.
In my personal belief, I think that anyone that is held under American force or just even under American jurisdiction should have that right to habeas corpus as well as due process rights. You can see that with Guantanamo Bay, they moved the prisoners off of U.S. soil into a territory that is not under the jurisdiction of America, and so those rights were legally removed. They did not have the writ of habeas corpus, nor did they have due process rights. And personally, I think that if you are being held under American force or just in American prisons, I think that it should apply to you as a non-citizen or as a citizen.
In my personal belief, I disagree with my colleagues in the sense that the extension of habeas corpus should not be given to non-citizens, but I agree in the stance of my colleagues in the sense of the removal of Guantanamo Bay or even trying non-citizens.
So what about habeas corpus and the state governments? Does habeas corpus place an unreasonable burden on state governments, and how does habeas corpus interact with state law or the state court systems?
Article 1, Section 13 of our Washington State Constitution establishes the writ of habeas corpus. However, it is not established in the way that it is in our Constitution. It does say that it shall not be suspended. However, it does guarantee that writ of habeas corpus to state citizens who are held under American jurisdiction. And I think that it gives a bit more context when talking about the writ of habeas corpus. It doesn't so much talk about only suspension, but it applies the right directly to citizens.
And continuing to answer the rest of your question, I do not believe that it places an unreasonable burden on the government because as we have the layered cake federalism in our government, should it be that states really do need more resources or assistance with processing the writ of habeas corpus and processing those who are being prosecuted under the law, they can rely on both the aid of local governments and our federal government.
To disagree with my colleague Maya and show that the burden it places, looking to Canada for an example, in Section 10 of the Canadian Charter of Rights and Freedoms of 1982, they institute habeas corpus and have had multiple issues of people using habeas corpus to change jurisdiction constantly in order to find a justice who sees their ideals that will allow that writ and let them retry the case.
All right, we're at time. Good job.
And I was going to ask you, what if Canada invades Washington State? Can you suspend habeas corpus? Oh, well.
All right. Good job, everybody. We're going to do feedback now.
All right. Thank you much. Over to Mark for feedback.
Thanks for the direction. Hey, I really enjoyed this. I got sidetracked stepping out from my judging responsibilities and getting engaged in your thought processes, which is great. Well done on that. Because that's what you're trying to do. You're trying to step it aside, and you're so comfortable with the subject matter that you're showing me you can engage in dialogue and engage in the nuances of the arguments and deal with our questions. Aristotle, you always score big points with me because I have a Greek heritage. And then when you pulled it in to your response, and I love the phraseology, the habeas corpus ensures that the due process of law is followed. And that, what I thought was that phraseology and that spin on it, I hadn't heard all day, and it kind of resonated with me. So you all of you had similar comments. You brought in Titled Chapter 28, and that's something that I haven't heard all day today. So by the end of the day, if you're hitting me with something new, that is fantastic. So that means you have to go deep into this stuff to be able to bring out and control the subject matter. I thought your presentation, your demeanor, your tone, your responsiveness to our questions was all really well done. So thank you.
Well, not that I don't like Aristotle, but one of my favorite philosophers is John Locke, followed by Thomas Hobbes. I'm not English, but I studied both of them in European intellectual history when I was in college, and was my favorite year-long course. It was just great. So you always win points when you quote Locke or Hobbes to me. So, but I have to echo what Mark said. Great demeanor. You guys worked so beautifully off each other. It was so seamless. You almost finished each other's thoughts. You were so into the subject matter. Love the reference to Canada. Love that you respectfully disagreed with each other and supported your reasoning, which is always important. It's not what you believe, it's how you support your reasoning, and you guys did. I thought your opening statement was very well prepared, and you really showed us that you had a very strong and nuanced understanding of what is a very technical area of the law. I would love to keep talking to you all night about your thoughts here and everything, but I really enjoyed the conversation, and always good to close. Can't go wrong by closing out your prepared statement with a quote from Alexander Hamilton, one of my favorite people, a New Yorker. Really well done, and very impressive. So kudos to your teacher for preparing you for today. So thank you.
Yeah. To echo my colleagues, you guys really played very well off each other. I thought that was tremendous. That first question out of the gate, one of you hit due process intertwines well with habeas corpus, and then another followed up with habeas corpus is what you use to challenge if due process is violated. You guys really built off each other very well. And as Karen also said, you really were able to also showcase that disagreement, to be able to showcase civil disagreement, which frankly this country could use a little more of, and also how you're able to showcase both sides of an argument within in a framework like this. Love the Canadian example. Love that you were able to bring it to Washington State. Just very well done.